Hi everybody. I was in the middle of making this video, doing an edit and a YouTube thumbnail. I was doing a little bit of last minute Googling, and the Times News Online just posted an article about an hour ago. It is just shy of 4 o'clock on 10/16/24 that did confirm that former Chief Bonner's wife is Carla Fritz. I do go through and read the lawsuit in this video, so if you're still interested in that, you can go ahead and continue listening. Again, I just appreciate that you're here. I appreciate that you're listening, and I appreciate your support. Thank you. Welcome to PA Trench News, your independent news report of Southern Pennsylvania. We pick up where legacy media leaves off, making sure to follow the stories the whole way through. So a while ago, I reported one of the civil lawsuits regarding the West Penn Police Department and Rachel Rossi. Rachel Rossi is suing the West Penn Police Department and former Chief James Bonner for excessive use of force. Rachel appears to be the daughter of one of the sitting judges in the area. So I was online looking for updates to that case, and I found another lawsuit. A woman named Carla Fritz is suing the West Penn Township. She was a former employee and is suing for wrongful termination. However, after researching Carla, I found that she may also have a connection within the community. Carla's address was listed in the civil complaint, and I redacted it for purposes of reporting on it. However, I did Google that address just to see what would come up. So this is a screenshot from the website that I researched the address at. It is heavily redacted. I erased all of the information that could be used as a contact for this person. I just wanted to pull it up to show you that I found her name with her listed address, past addresses, and phone number. But I also found another person whose name will sound familiar listed at the same address. And here it is. There is a James Bonner listed to live at the same address as Carla Fritz. Again, this screenshot is heavily redacted for obvious reasons. We do not promote anybody contacting, doxing, harassing these people that are being reported about. So for their safety, everything has been taken out. You can choose to believe this reporting, or you can do your own research, which I always recommend as well, to see the unredacted information. However, as always, we are not going to be contacting, harassing, doxing any of the people reported here. So with all of that being said, James Bonner is the same name as the former police chief of the West Penn Police Department. So it looks to me that Miss Fritz and Mr. Bonner both worked for the West Penn Police Department, are both former employees at this point, and both live together in the same household. I don't have any information regarding their exact relationship, but I'm sure that somebody out there does. If you're curious about the lawsuit, stick around, because here is where I read the whole entire thing to you. Filed in the United States District Court for the Middle District of Pennsylvania is Carla Fritz, the plaintiff, versus West Penn Township. And here is the complaint. And now comes the plaintiff, Carla Fritz, by and through her attorneys, and it veers as follows. Plaintiff initiates this action to seek redress against the West Penn Township, hereinafter the defendant, her former employer, for unlawful discrimination in violation of the Americans with Disabilities Act, hereafter the ADA, unlawful ADA retaliation, violations of the Family Medical Leave Act, hereinafter the FMLA, wrongful discharge, due process claims under the 5th and 14th Amendments to the U.S. Constitution, Fair Labor Standards Act, the FLSA, violation, Pennsylvania Wage Payment and Collection Law, the WPCL, and violations of other applicable laws. The parties. The plaintiff is an adult and competent individual. The defendant, the West Penn Township, is a government unit, a township located in Schuylkill County, PA. Jurisdiction. This gives the information that proves that where the lawsuit was filed in the Middle District Court is in fact the correct court, because these actions happened in the jurisdiction of that court. Here is the factual background. Plaintiff was employed by West Penn Township as support staff for the police department from September of 2021 until her employment was terminated on October 7th, 2023. Beginning in 2022, Glenn Hummel, a township supervisor, who was a liaison to the police department where plaintiff worked, constantly harassed the plaintiff. The harassment became so severe that in August of 2023, plaintiff sought medical care. On August 9th of 2023, plaintiff's physician diagnosed her with severe anxiety related to work-related mental stress. On or about August 9th of 2023, plaintiff requested leave under the FMLA Act. At or about the same date, plaintiff asserted her rights under the PWCA Act. At or about the same date, plaintiff asserted her rights under the Pennsylvania Workers' Compensation Act. Shortly thereafter, plaintiff's FMLA leave request was denied. In response to the denial, plaintiff reported the employer to the United States Department of Labor related to the FMLA denial. Shortly after plaintiff's Department of Labor complaint, the employer reversed course and approved plaintiff's FMLA leave request. On August 22nd of 2023, defendant denied complainant's workers' compensation claim. Plaintiff took FMLA from August 10th of 2023 to October 7th of 2023. Based upon plaintiff's physician's notes, on August 9th of 2023, defendant cut plaintiff's hours. Plaintiff did not request a reduction in hours. The reduction in hours was retaliatory. In retaliation of the plaintiff exercising her disability-related rights under the FMLA Workers' Compensation Act, defendant undertook a campaign to force plaintiff out of her job, which consisted of increasing workplace harassment, threats that her employment would be terminated, a cut in hours, and refusal to pay for hours worked. The threats to plaintiff's employment escalated dramatically once the defendant was advised of plaintiff's disability. Finally, on October 7, 2023, defendant terminated plaintiff's employment, citing budgetary reasons. Count 1. Plaintiff is a qualified individual with a disability, as the term is defined in the ADA, because she has and has had at all times relevant hereto a physical or mental impairment that substantially limits one or more of her major life activities, or because she has a record of such impairment. Particularly, plaintiff's anxiety affects many major life activities, including sleeping, working, or thinking. Despite her condition, plaintiff was able to perform the essential functions of her job. Additionally, plaintiff was perceived or regarded by the defendant as having impairment substantially limiting one or more of her major life activities. The foregoing conduct by the defendant constitutes unlawful discrimination against plaintiff based on her disability or perceived disability. As a result, the defendant's unlawful discrimination, plaintiff has suffered damages set forth herein. Count 2. ADA retaliation. Paragraphs 1 through 34 above are incorporated herein by reference as if the same were set forth fully herein at length. When plaintiff asserted her disability-related rights under ADA, she was engaged in protected activity. When the defendant cut plaintiff hours, it engaged in adverse employment action. When the defendant harassed plaintiff and tried to force her to quit, it engaged in adverse employment action. When the defendant terminated plaintiff's employment on October 7th of 2023, it engaged in adverse employment action. All of the aforesaid adverse employment action was contemporaneous with or in close temporal proximity to defendant's learning of plaintiff's condition and plaintiff's protected activity, sufficient to raise an inference establishing causal connection between the employee's protected activity and employer's adverse action. The defendant does not have a legitimate, non-discriminatory reason for its adverse employment action. Wherefore, plaintiff seeks damages as set forth in Count 3. Disability discrimination failure to accommodate. Plaintiff's severe anxiety is a disability within the meaning of ADA. On August 9th of 2023, when the defendant was advised of plaintiff's disability and request for leave, defendant had a duty under the ADA to engage in an interactive process with the plaintiff and her physician to provide leave as an ADA accommodation, apart from the employer's responsibility under the FMLA. The defendant did not make a good faith effort to assist the plaintiff. The request for leave as an accommodation was reasonable. The defendant's failure to accommodate violated the ADA. Count 4. FMLA interference. Plaintiff requested FMLA leave on August 9th of 2023. She was eligible for leave based upon her own serious medical condition, particularly severe anxiety related to work-related mental stress. The defendant was at all times relevant hereto a covered employee under the FMLA. Defendant had proper notices of the employee's need for the requested leave, as the plaintiff requested said leave and provided medical evidence in support of the same. The defendant interfered with plaintiff's rights. One defendant denied plaintiff's FMLA request. Count 5 is FMLA retaliation. As stated above, plaintiff requested FMLA leave on August 9th of 2023. Plaintiff's FMLA request was based upon her own serious medical condition. Additionally, plaintiff asserted her FMLA right when she reported the employer to the United States Department of Labor related to the FMLA denial. Following plaintiff's engagement in above protected activity, plaintiff's hours were cut. Following plaintiff's engagement in the above protected activity, plaintiff was exposed to increased workplace harassment. Following plaintiff's engagement in the protected activity, plaintiff's employment was terminated. Each of the above instances of adverse employment action were in close temporal proximity to the plaintiff asserting her FMLA right. Each of the above instances of adverse employment action was in retaliation for plaintiff's exercise of her rights under the FMLA. Count 6. The wrongful discharge pursuant to the public policy exception to the at-will employment doctrine. On or about August 9, 2023, plaintiff asserted her rights under the Pennsylvania Workers' Compensation Act. Plaintiff had a valid legal right to assert her rights under the Workers' Compensation Act. The exercise of employee rights under the Workers' Compensation Act constitutes a clear mandate of public policy. Defendant denied plaintiff's claim under the Workers' Compensation Act. After plaintiff asserted her rights under the Workers' Compensation Act, plaintiff was exposed to increased workplace harassment. Following plaintiff asserting her rights under the Workers' Compensation Act, plaintiff's employment was terminated. Above instances of adverse employment action were in retaliation for plaintiff's exercise of her rights under the Workers' Compensation Act. Retaliation against the employee for exercising her rights under the Workers' Compensation Act is so obviously against the public health, safety, morals, and welfare that society holds a virtually unanimous view of its importance. Plaintiff was an at-will employee of defendant. Although the plaintiff was an at-will employee, the employer's privilege under the at-will employment doctrine to dismiss an employee for any reason or no reason at all is not absolute. When an employee is discharged in a retaliatory manner for exercising her rights under the law, and that law constitutes a clear mandate for public policy, an exception to the at-will doctrine is created, and the employee may sue for wrongful discharge. The defendant's conduct in terminating the plaintiff in retaliation for exercising her rights under the Workers' Compensation Act was purposeful, willful, self-interested, wanton, and outrageous. It is necessary that the plaintiff in this matter seek punitive damages to protect herself and others from termination for exercising their rights under the Workers' Compensation Act. Wherefore, plaintiff seeks damages set forth. Count 6. Lack of due process. Because the plaintiff was employed by the government, she had a constitutionally protected property interest in her employment with the defendant. A deprivation of property rights must be preceded by notice and opportunity for a hearing. In the employment context, the employer must provide a pre-termination hearing that includes the opportunity from the employee to respond to the allegations against her, to be able to provide her side of the story. In the instant matter, no such opportunity was afforded plaintiff. Count 8. Fair Labor Standards Act violations. At all relevant times, defendant was and continues to be an employer within the meaning of the FLSA. Defendant failed to pay plaintiff for all hours worked and failed to pay overtime compensation at a rate, if not less than 1 and 1.5 times the rate in which the plaintiff was employed, for work performed beyond 40 hours in a given week. In the period of September of 2021 through October 7th of 2023, plaintiff's work shift was 8 a.m. to 5 p.m. with 1 hour uncompensated lunch. During the above period, plaintiff never took her lunch because she was unable to do so. During the period of September 2021 through October 7th of 2023, plaintiff was not compensated for 516 hours, having worked through her uncompensated lunch each day. In September of 2021, the defendant asked plaintiff to clean and paint the defendant's offices in addition to her support staff position. Because plaintiff was not able to do the cleaning and painting during her regular work hours, plaintiff did the work in the evening hours and on days off. Plaintiff was told by Supervisor Hummel to keep the time and use it as future comp time. In September of 2021, plaintiff performed 40 hours of uncompensated work, cleaning and painting. Plaintiff performed additional cleaning and painting in January and February of 2022 under the same arrangement. In January and February of 2022, plaintiff worked an additional 40 hours of uncompensated time. When plaintiff's employment was terminated in October of 2023, she asked to be compensated for the 80 hours of uncompensated painting and cleaning, only to be told to prove it. In total, plaintiff was not compensated for 596 hours. In addition to the 596 uncompensated hours, those hours resulted in plaintiff working in excess of 40 hours in a given week. Plaintiff was full-time 40-hour per week employee. However, when you add in the one uncompensated lunch hour per day, plaintiff worked 45 hours per week, September 2021 through October 7th of 2023, exclusive of her cleaning hours. Based on the uncompensated lunches, plaintiff was not paid 535 hours for overtime pay. Plaintiff's regular rate of pay was $18 per hour. In September of 2021, the plaintiff was not compensated for 40 additional overtime hours. In January and February of 2022, plaintiff was not compensated for an additional 40 hours. The actions of the defendant detailed above were willful. The defendant knew or should have known that failure to compensate employees for lunches they worked through violated the FLSA. The defendant knew or should have known that failure to compensate employees at all for work they performed violated the FLSA. The defendant knew or should have known that their actions set forth above would result in employees exceeding 40 hours in a given week and not being compensated with overtime pay. Under the FLSA, the employees are entitled to recover from defendants their unpaid overtime compensation, minimum wage for uncompensated time, an additional and equal amount of liquidated damages, reasonable attorney's fees, and cost of the action. It is believed and therefore averred that the defendants did not keep accurate records which provided plaintiff's full name and social security number, full and complete address, sex and occupation, day and time of the week when her work week began and ended, hours worked each day, total hours each work week, basis on which plaintiff was being paid, hourly, weekly, piecework, regular hourly rate of pay, total daily or weekly straight time earnings, total overtime earnings for the work week, additions or deductions from her wages, total wages paid each period, date of payment, and the pay period covered by the payment, and did not accurately record hours worked in a given day. Count 9. The WPCL provides a mean by which employees may collect wages and compensation of any kind held by their employer. It includes severance pay, vacation pay, holiday pay, guaranteed pay, and any amount to be paid pursuant to agreement. As set forth in detail above, the plaintiff was entitled to be paid for all of the hours she worked. Plaintiff worked through lunches for which she was not compensated. Plaintiff was promised that she would be compensated for the cleaning and painting she did, but was paid nothing. Plaintiff was promised wages which she was not paid, which constitutes a breach of contract. In Pennsylvania, contracts under the WPCL may be oral. And this is the prayer for relief, meaning this is what the plaintiff wants. Under the WPCL, plaintiff is entitled to recover from defendant her unpaid compensation, unpaid overtime compensation, and additional amount as liquidated damages, reasonable attorney's fees, and the cost and disbursement of the act. Signed, her lawyer. That was a tough one to read through because it's very analytical, very law heavy between not only the complaint, but also the different laws in which they are being accused of violating. It's absolutely bonkers to me if it is true that they don't have like a clock in, clock out system, that they weren't like, was this person paid under the table? And if so, that's really bad as a government agency. I don't understand how they didn't have a clock in, clock out system, how they weren't withholding funds like every employer does or has to do. So there is some more information about this lawsuit. There is a response that's pretty bland. There's an amended complaint. I'll go over those in another video because I think this one is just so information heavy with the actual legal argument. It just blows my mind, because it appears that Miss Fritz is cohabitating with Chief Bonner and was working for the police department. Mr. Bonner was working for the police department as the chief, and somehow this woman was paid, but not through a payroll system. I don't know. So if you have made it this far, thank you so much for getting through that with me. If you don't mind, please like, comment, and subscribe to help this channel grow. If you're listening on your favorite podcasting app, please download, rate, and review. If you would like to Cash App me to help support this channel, you can Cash App me at $PA Trench News. Until next time, guys, thank you.